everyone, welcome to LexTalk, World Talk Show presented by ClickAway Creators. Today we have Mr. Someshs Tiwari with us. Mr. Tiwari is currently the managing partner at Vardharma Chambers. He has been practicing before the Hon'ble Supreme Court of India and Hon'ble Delhi High Court in matters focusing on arbitration, Prevention of Money Laundering Act, banking, company law, and matters related to writ jurisdiction. Somesh has represented clients across various high courts in India, touching matters in criminal, civil, and constitutional law. He has also been appointed by leading public sector undertakings to represent them before various forums. I have a lot to talk about, Mr. Tiwari, but let me just introduce you to the man himself. Hello, Somesh. How are you?
Hi, Bharti. Thank you for this long, illustrious introduction.
So I just want to tell everybody here that Somesh wanted his intro even shorter than this. So this is the reason, I did not say much. I had a lot to talk about, but then I'll just leave it to Somesh. All right, Somesh. So please brief us about your journey as a legal professional so far.
My journey as a legal professional so far. See, I feel that every person who's practicing law in India or anywhere in the world has their own ups and downs in their legal journeys, and I went through the same. I graduated from Bombay University. I came to Delhi, and I personally feel that I was very blessed to have a senior who gave me the opportunity to work on my own cases and bring my own cases and build a small clientele of my own, which really gave me the idea of going further ahead and then building my own small practice, what you call. And it's been amazing since then. I've had the opportunity to work with one of the best, most amazing people in the legal industry. We've briefed some of the best, most amazing legal counsels in the country, from Delhi, Bombay, Supreme Court, High Court, Allahabad High Court. And so far, it's not that far, but so far I've already realized that I feel that in my profession, in the time that I have, the small morsel of experience that I have gathered, that I feel that we as a community is a very symbiotic community of lawyers, and we need to usually work together and bring out the best interests for our clients. And that is the one lesson that I carry with me with all the matters and cases I do. And also, a small thing that I also think about always is that you should always have empathy. A lot of people who come forward and tell me, boss, you can't get too engrossed with the problem of the case and look at the case as it is. But I somehow fail to do that. I would always have some kind of empathy with the client, even though there are people who would say completely contrary to what I believe. But that's my journey so far it's been amazing. I am a third generation lawyer in my family. My grandfather was a senior advocate in Allahabad. My dad was elevated as a judge at a very young age, while I was still in school actually. And I always wanted to be a lawyer, not because I had a family background or not because my dad was where he was or my grandfather was where he was, but I always wanted to pursue law because I grew up watching my parents, my father, and everybody in my family pursuing law, and I always felt a kind of a connection, and that's how I picked up law, and we are where we are today, and hopefully better 10 years from now. And that's what it is.
Wow, that was really modest of you, Mr. Tiwari. But moving on, let us talk about your most memorable transaction. I'm sure it is a very unfair question to ask, but I'm gonna ask anyway. I'm sure there must be one thing or one particular case or transaction that it leaves a deeper impact than any other transaction or case. So let's talk about that and key takeaways from there.
As you very correctly mentioned, that it's going to be very difficult it's very wrong to kind of pinpoint some incident, because I'll tell you what, I have realized that every case that you've done in your life and every good order that you've got from a court is memorable in its own way. Whether it's from a district court, from a high court, from the Supreme Court, from a tribunal, because it carries the kind of impact in terms of your own practice, and it tends to change the kind of practice you want to have in the future. It helps you create a sense of say a sense of where you want to be in terms of your practice. So if you can't pinpoint each and every, I think all cases are very memorable. It will be very unjust for me to try and pinpoint a specific memorable case. However, I'll tell you, I think of all the cases that I have done so far, uh, there was a case that I undertook a very nascent stage of my career. I think my first year, less than a year of practice that I took this up. It was a medical negligence case, and it was against a very, very reputed hospital in Delhi NCR. And the child was a 12-year-old boy who died of typhoid, and there was a massive bill that was given to the father, and this family was incredibly poor. They couldn't have the means to afford the legal kind of remedies that are available to every person in the country. And I felt right away that if I kind of impress upon him the idea of not pursuing cases and trying to get what he's already paid, that would have been better. Because I personally feel that in our country, the kind of infrastructure we have today, very unfortunately, it doesn't serve or cater to the people who are at the very lowest strata of our society. And if I, for my own selfish reasons, if I tell someone to please file a case and make some small amount of money out of it, I don't think that's right. So, to be very honest, this matter, when I got the case, we got through we did a lot of research, and there was a massive gap in the terms of the bill that was raised and the terms of medicines that were the procedures that were undertaken on the child, and the child had already passed away, and there was a massive bill of around 16-17 lakh rupees. And the total net, I mean, gross income of this gentleman, his father, was not more than what, 80-90,000 a year. And so we got together, we put forward a research, we went to the medical board, we argued before the medical board that look, there are massive discrepancies in the prices of the medicine that has been given, administered. There's a 200-300% margin. And we were very successful in getting the entire amount back that he had paid, because he had to sell his own house to pay for the treatment. And I feel that a case wherein you don't really have to go to court and you win, that are the best cases. Because if you sit and expect a person on that strata of a society to wait and litigate for 10 years, 5 years, 6 years, I think that's massively unjust. So that is a case, and the very key highlight takeaway from that matter was that I would always want to be humble and give more than that you get. If I have an opportunity to work on pro bono matters, if I have an opportunity to represent someone who I feel that he can't, or this person can't, then I am hands on always. And there's a catch to it also, because sometimes they always come forward and show you that look, I can't afford it, but they can. There is a catch to it also. But even then, I feel that even then, why waste the opportunity? If you have a person who's saying that, look, I don't have the means, I have already suffered a lot, and let them have access to basic justice, then I think that's a massive victory on your behalf.
Wow. Now I understand why you were saying that it is very important to be empathetic.
Yep.
Because if you do not have that, I'm sure if you did not have that kind of trait, then you would not be able to understand the other person's position. So thank you very much. And I'm really glad that these were your learnings. So diving into more knowledgeable things now, and also your specialization, I'm really interested to talk about that. So I'll just leave it up to you. Should we talk about the Prevention of Money Laundering Act, way forward, and the SC view in shaping the law, or should we talk about the consumer disputes redressal in 2021?
Use either. I mean, all of them. I'm comfortable with all.
Let's just talk about the Prevention of Money Laundering Act first.
There are people who have been practicing this area for the past so many years. However, in terms of Prevention of Money Laundering Act in India, uh, we need to understand why this act had what was the reason why this act was introduced in India, and why I personally feel that this act has been statute has been a massive failure in terms of what it wanted to achieve. Because I think this is not being deliberated properly, and it has not come forward with a very clear idea what exactly do you want from the statute. I'll be very concise with what I want to say. Like for example, we had when the scheduled offences were added back in 2009. Since then, you've seen a massive shift in terms of ED and its cases since 2016-17. Because you keep reading in newspapers, because I think before 2016 a lot of people are not even aware what ED is, and there's a central agency that caters to all of this money laundering business that goes on in India. And we usually had SFIOs and CBI and all of these matters, and ED came into picture much later. But as per the statute, I feel there is a massive gap in understanding what the statute actually entails. According to me, there's a three-pronged problem with the statute. Number one, if the main area of focus in the statute is to punish the offender of money laundering, and that is the main simple criteria, I think you failed in understanding why money laundering as a statute should have been brought in. I think the very basic reason of money laundering statutes and why it should be, it shouldn't be about definitely focusing on the offender and the offense and punishing him. It is wrong. I feel that the very first criteria should be getting the money back to the exchequer. For example, take any money laundering case. Take Nirav Modi, take Vijay Mallya, take all of these big scams. These people allegedly have offended. They've gone and there's a fraud to the bank. They've taken massive amounts of money from these banks, and that money has now gone in. There are three types of money laundering: there's layering, there's integration, there's diversion. And they've taken the money out, and the money somewhere. The investigation is still on. The courts are still to this matter still sub judice. So I don't want to comment on why and what the court should be doing. I don't want to do that. But let's take that example. If in a situation like a massive scam like Nirav Modi, wherein it's running into thousands of crores, your main criteria is to go on a witch hunt all the way to London and do an extradition, bring him back, and then punish him, you failed. If you were focusing on getting the money back initially, because this money has gone from where? This money has gone from the exchequer. The people of India have lost their money. So if your basic default go-to approach is to punish someone, that's all right. I mean, punishment is okay, but that cannot be your primary approach. And that is why I feel that EDs today has become a witch hunt agency, which has been thrown after people to put forward a showcase of look how amazing the ED is working. But I think if you do that, it's a massive failure on the enforcement directorate. And I think even in the statute for in terms of attachment of property and then confiscating, and that matter goes on to the High Court, then goes to the Supreme Court. Till now, in the past 10 years, the central government has been able to finally confirm a couple of like maybe one or two properties. And by the time you confirm and then resell and get your money back, you will not even get 10% of the main property value. And you've invested massive amounts of time, money, energy, infrastructure. And let's not even get into infrastructure, because the ED is going on attaching properties across India, running into thousands and lakhs of crores. But their own Kasi Judicial Authority, the adjudicating authority, doesn't have legal members, doesn't have a chairman. It has one technical member. And I'm so I'm actually overwhelmed to think that we have such an amazing staff and amazing, court staff that works in these authorities who are working under such massive pressures with cases piling on. It's bursting at the seams at the moment, but they're still holding on and they have to work under 180 days and finish it. I think in terms of money laundering statute, it needs a massive deliberation. I think in terms of attachment, burden of proof under section 24, section 24 burden of proof, I mean, it's actually downright draconian. So to give you an insight, section 24 burden of proof actually says that, look, I'm going to attach your properties, you are the offender, please come forward and now tell me why I shouldn't be doing this. So you have the infrastructure, you have the investigating authority, you have your own quasi judicial authority that confirms or denies that attachment, and then you've put the onus back to the person. Even in the NDPS Act, which is a sister kind of an act, but it's I think it's completely wrong to do this on even as a country like ours, when the world looks up to you, for your democratic ways of doing things. This is a massive failure on your part to show that, look, I have a draconian feature like reversal of burden of proof, and this is being challenged across India in multiple courts, multiple forums. There's no hearing. So if you keep continuing like this, I think the statute, at the end of it, the statute needs a massive restructure, and we need to sit and concentrate and consolidate the fact that where are you going from here? If your primary objective is punishment to an offender only and nothing else, you failed as a statute. That's what I personally feel.
Well, Somesh, thank you. But that was quite an insight. I'm sure you are going to make a lot of controversies with this as well. Like people are going to drop in a lot of questions, a lot of comments. So I hope you're ready for that.
I have to speak my heart out. What I feel,
Absolutely.
I think it's a massive lapse in terms of the procedures adopted by an authority, and I have to speak my heart. If I don't, and we keep just lying down and can keep taking it, I think we as a fraternity of lawyers, we are officers of the court, and wherein we fail to address such issues, I mean, who will?
Right. If not us, then who? All right. Thank you very much, Mr. Tiwari, for throwing light on the Prevention of Money Laundering Act. Now, let us talk about your views on how do you look at consumer dispute redressal in 2021, and if you had anything to say in terms of how it is going to change maybe 5 years down the line.
See, when I started my practice, I was very fortunate because my senior gave me the authority, or gave me the permission to go and argue matters from the first date in the consumer forum, and even in the state forum and the national consumer forum. I had that I had that privilege, to be very honest, to argue before a bench, and throughout, not even like singly on applications or a basic date. I was given the authority to argue matters, and I'm massively grateful for my senior. Talking about where it is today, excuse me. Talking about where it is today, I feel that very recently there was an amendment in the Consumer Protection Act. I think we have again failed to address what we actually want, even in the Consumer Protection Act. See, I'll tell you why. There was this, because I've been practicing in the consumer forum for a very considerable time now, and I've seen this shift in terms of practice and procedure, and how judges now have shifted their viewpoints in terms of consumer practices. When I started very recently, after a couple of years, there was this very famous Amrish Kumar judgment, Ferris Infrastructure, wherein the full bench of the consumer court, National Consumer Forum, sat down and they deliberated, and they said, listen, because we want to make it easier for effective remedial of disputes of consumers. We will there was a threshold, a pecuniary threshold, wherein consumers can come together, and if the value of the goods and services together crosses that threshold, then they can come to the national forum directly, which I believe was a massive step. And I think I was very, very happy, because that enabled the consumers to directly approach the highest authority. And at that point in time, even maybe today, but at that point in time, there was a very massive massive disputes regarding builder buyer disputes. There were consumer complaints wherein builders were brought in, and the complainants were alleging a very high interest rate to meet that pecuniary jurisdiction. So the court has set a fantastic set of guidelines as to who can come and who cannot come. And everything was said and done. And I feel that was the reason behind it. I feel personally that was the reason behind it. But unfortunately, what happened was, very recently the amendment came in and they increased the threshold massively. And when you've done that, now section 12, 1B and 1C, at one point in time, you've enabled a person to approach the national forum, but now due to the amendment, you're saying, no, please don't come here, go back to the state consumer forum. Right now, these authorities are bursting at the seams in terms of infrastructure, in terms of judges, in terms of court staff, in terms of infrastructure for even warehousing of your files. And I've been to these state forums, and there's a massive lack. So now you've pushed all of those people who had come to NCDRC back to the state consumer forum.
Right.
Yeah, and now that has now become a very big problem. In the midway, there is another issue that most of these developers have gone into IBC. So the consumer right now is confused. Should I go back to the state consumer forum? Should I go back to the national consumer forum? Should I sit and wait for IBC? IBC, the developer will get liquidated. What will I get from it? And I have had the privilege and the opportunity to represent some very big housing societies in Delhi NCR. And the very basic question these people ask me is like, kahan jaye? Where do I go? Because the amendment itself has increased the jurisdiction, fair enough. But how to tackle it? Because you've not put in the same infrastructure downstairs. And you've sent all of these people back to the state consumer forum. So at this moment now, very recently, the Supreme Court came up with a judgment that this judge, wherein the amendment will have retrospective effect. But the NCDRC then gave a judgment, I think a couple of days later, that look, this will not have retrospective effect. There was a small distinguishing factor in terms of this judgment. So right now there's a confusion and chaos in terms of where to go. If you want to enable the consumer of your country to approach and get redressal of his disputes, it has to be quick, it has to be robust, and you must have that infrastructure. If you lack these 3 points, I feel you can't move ahead for with a statute wherein you want to help the consumers at large in India. So that is where I feel. But 10 years from now, I think, or maybe 5 years from now there's a growth in online marketing, on online shopping. There's a massive growth in people who are buying stuff from websites across the Indian borders. How do you address those issues? Because sometimes these commodities run into lakhs of rupees. Sometimes you maybe it's a very expensive jacket or a very expensive watch that you've called for, and that's defective. What do you do? This certain kind of company doesn't have an office in India. These are issues that should have been actually addressed. I feel it has not been. We are still going on with the same old fashion of, okay, the first day you file a complaint, it comes up later, then you file a reply, there's a rejoinder. If you don't make it fast, it's useless. I mean, and the consumers today are looking for an effective, fast redressal of their disputes. And in builder buyer agreements, so it's a massive failure. But 5 years from now, I'm thinking that this the Consumer Act and the consumer forums should be getting a good infrastructure, enhancement, and this will be addressed, because I'm actually very hopeful, because at the way the courts are being addressed and the procedure has been adopted, I'm very, very happy in terms of how these forums are now working, and they've done a massive service to the consumer community in India. And I think it's going on the right track, but there are issues that need to be addressed, of course.
Okay, Somesh. So when we were talking about the issues, just out of curiosity, I wanted to ask that when these changes are taking place, what happens to the ones who are already in the process?
When the changes are taking place,
like now there's a change, now there's this amendment, now there's this amendment, but
they're stuck.
sorry,
If you want a real answer, they're stuck. Because
alright.
because I'll tell you, let's understand this from a very different viewpoint. Earlier, if you filed a consumer complaint very earlier, I'm talking about 2016-17, you reached the stage of final hearing in about a year, because the pendency of cases at the consumer forum was less. Now what has happened is, because that fairest infrastructure judgment happened, a lot of people approached the NCDRC, and you will not believe the hallways of the NCDRC right now has files, stacks of files. It was that massive. So in order to curb that, then you came for with an amendment. So if a very clear answer to people who are contesting consumer complaints, especially with reference to builder buyer agreements, you are stuck. Because some of these, say for example, some of these cases are against very huge builders, and the Supreme Court is already seized with those matters. And then now, so they are in a situation, boss, we are stuck in RERA. We are also in consumer quorum, because these both proceedings can go harmoniously if there were multiple judgments on this. And by the time I was about to reach my turn for a final hearing, the Supreme Court is now seized of the matter. If not, the IBC is walked through. Is this a redressal? I don't think it is. I don't think it's. See, again, I'm going back to my same point. If it's not quick redressal, it's not redressal. You're trying to remove a band-aid slowly, and it's more painful. If you want to address a situation, address it properly. I mean, that's what the issue is. But again, right now, if the vacancies are filled in time, which is also a massive problem in India, the vacancies in these tribunals are filled in time. And I personally believe that, see, Consumer Act it's not rocket science. It's simple. A person who's given money for goods and services has got defaulted goods or services, and he expects his money back, or that good or service in better form, and that's basically it. And redressal in these issues should be taken up and swiftly done with. That's the idea. If you can't do that, then if you have to wait for 4 years to get your flat, which is already late for 10 years, then you're now 14 years. Where are we going from here?
Thank you very much, Mr. Tiwari, for throwing light on the consumer dispute redressal in a very elaborative manner, of course. So, Mr. Tiwari, please enlighten us with your views on the 107 Parliamentary Committee report suggesting regional benches of the Supreme Court and appointment of judges.
See, very recently, not very recently, but a certain time ago, your Vice President, Mr. Venkaiah Naidu, had suggested that there should be regional benches of the Supreme Court in India. And then after that, in the aftermath, there were a lot of people who came forward and said, look, this is a good idea. But there are pros and cons to it. Let's talk about the pros. So look what happens in the US. There is a state Supreme Court. Every state has their own Supreme Court. And there is a federal court. There's a federal Supreme Court. And matters or offences related to the federal, when there's a federal offence that goes to the Supreme Court directly. Now, today in India, we, according to me, and this is very, very strictly a very personal issue, but we are a population of around 1.3 billion people and growing. If you expect 34 or 32 odd judges to have that kind of weight on their shoulders to work across the year and finalize these cases and hear them finally, I think that's just unjust on the judiciary. I think that's wrong. Secondly, I feel that a person who lives in Mizoram or Nagaland or Tamil Nadu or Kerala, he does not have access to justice when it's coming to Supreme Court, does he? Because now this person who's living in some farthest corner of the country has to travel all the way to Delhi, find a lawyer, file a case, keep on with it. It's very expensive. Number one. Number two, it's time taking, and not everybody has that kind of energy to kind of take it forward like that. And I was very happy when the hybrid system was taken up by the Supreme Court, by the honorable judges, wherein all of these cases were heard, and a lot of these cases, around I think 50,000-60,000 cases, were disposed of, and that's a massive number. And these cases were disposed of by the Supreme Court in record time.
That's a huge number considering the backlog that we have.
Right. At that time, I thought that why don't you implement this throughout the nation? If you have someone who's in Tripura or Meghalaya or Kerala or maybe Tamil Nadu, these people don't have access to this. He will just go to his local lawyer, open his computer laptop, and then argue the case out. So these are the pros, and access to justice, I think, takes the lead. In terms of regional benches, I feel that yes, it's now coming to that time, because Supreme Court, where Justice Chelameshwar had said, that it's a massive waste of the Supreme Court's time, because we are hearing, matters regarding transfer petitions, matrimonial, bail matters, but they have to, and then you take up that kind of time of the honorable judges, and I think it's a little unfair to them, because they have to work, read these cases, come every day, then they have administrative work as well, because you're the top court of the country. And we expect, because we don't see what goes on beyond the dais and the room. We think kya hoga, he just person has to come, listen to the case and decide and go home. No, it's not. These people work 14, 12, 14, 16 hours a day at times. And if you want to put that kind of pressure on judges, I think the delivery system of justice also gets affected. So if you have regional benches of the Supreme Court, I think that will ease off the pressure. And the Supreme Court here should have a federal kind of a court, wherein it's hearing matter of constitutional vires, challenge to constitutional vires, election petitions, state disputes, bigger matters, with wherein there has to be that kind of a level of deliberation. And when you have state Supreme Court, doesn't mean that your power is some kind of altered. I don't think that's the truth, because you will always have that kind of precedence over the other courts, because you are the federal court. And I feel in terms of appointment of judges, I think a lot of previous honorable Chief Justice of India's, I think Justice Deepak Mishra also, and Justice Kher also, they also said that it's bringing the judiciary to a grinding halt. Very recently, I think the Supreme Court said that there has to be a guideline set, so that in what time these, when there is an appointment that has to be done, the recommendations are sent to the government, and the government has to now come back with their affirmations or denials. So there has to be a timeline to all of this. You can't keep it hanging abyss, because you can't wait for these appointments, because now this is bringing the system to a grinding halt. So in terms of appointment, I think that is a very, very important step that has to be undertaken right now. And in terms of regional benches, I think it's time. Why? Because we have a massive population to cater to. and it's very difficult for people from different areas and different practices, different parts of different parts of India to travel all the way to Delhi and fight their cases. So even if you have virtual courts, even on admission hearings, I think that will be a very good step. Very, very good step. And that is, I think that was suggested by, the same was suggested by Justice Chandrachud as well. That you can have, at least for admission hearings, you can have, virtual courts. Because you have to give access to justice to these people. You can't expect someone from, again, Guwahati or maybe ends of Rajasthan to travel all the way to the Supreme Court for one day. Maybe the matter doesn't get heard. Maybe there's another date. Maybe there's an adjournment. The poor chap has to go back again, then come back on the next date. It's I think it's downright inhuman to subject someone to something like that.
Well, thank you yet again, Mr. Tiwari, and I guess we need more voices like yours so that things can be done in the best way possible and in everybody's favor. So thank you so much for sharing such great insights with us, and we really look forward to having a chat with you again in the future on some other trending topics in the international legal industry. It was a pleasure having you here, and thank you for sharing everything that you could with us on different topics, of course. And for our viewers, if you like this chat with Mr. Tiwari, please like and share this video, and also subscribe to Clickaway Creators YouTube channel to appreciate what we do, and you have more coming from industry legal leaders. This is Bharti for LexTalk signing off. Take care. Bye-bye.